Aloha, I'm Paul Soenksen. I'm senior counsel at Coates & Frey. And in that capacity, I help assist and manage some of our litigated cases heading to trials. What exactly is divorce litigation? Well, if you had the chance, you probably tried to start your case with a settlement offer or a settlement proposal to the other side, and perhaps it was rejected. There's also times when you can't start your case with a settlement proposal. Examples of that would be when you don't have enough information on all the issues to make intelligent choices, and you have to acquire that information in the litigation process. Another example would be that there are significant problems and issues that cause you to have to go to family court first for solutions on those temporary issues before you can get to thinking about settlement. So how do you find yourself in this disputed litigated case? Well, you had a rejected settlement offer, or again, you're in on urgent issues. Let me talk about the urgent issues. You may have to file what's called a motion for pre-decree relief. And this is where you're going to court to tell the court what some of the temporary or immediate issues are that need resolution, because we can't agree on them yet. These could be things like time sharing and custody issues with the children, child support, whether alimony should be ordered, the payment of various debts, maybe who lives in the house and who moves out, for example. If you have to file a motion for pre-decree relief, the procedure is that you gather up your financial and other related information if there's custody issues, and you present that in a motion to the court. The other side has to respond with similar information. The court has a hearing involving just the two parties, which occurs about a month after you filed the motion. Sometimes the court will shorten time on such a hearing if there are urgent issues that have to be resolved right away, but this is the exception to the rule. I also mentioned that sometimes you couldn't make a settlement offer because you didn't have enough information about certain issues at the outset of the case. This points you in the direction of a process known as discovery in litigation. The discovery process is a set of tools by which we acquire information to help us move forward in the litigation of the case. These could be things such as a request for production of documents, where you ask the other party to produce certain documents and they are expected to do so if the documents are within their custody and control. Another tool is the request for answers to interrogatories, and this is where you advance a set of questions that the other side has to answer. A third tool is a request for admissions, and this is where you make a set of usually simple factual statements that the other party has to admit or deny, and if admitted, these become evidence. If the other party fails to answer your discovery request, you can ask the court to compel them to do so. Another tool is a deposition, and this is a question and answer session where your attorney asks questions of the opposing party and they answer them. A court reporter is present and takes down all the discussion between the attorneys and the deponent. Two things that are fundamental to divorce litigation are this. One, you need to have a set of reliable and correct financial statements, which is the asset and debt and income and expense statements. And two, you want to have prepared a property division chart that helps you understand the issues as the case is moving forward and what discovery is necessary, and eventually will be used with the court to help prove your case. As the case is getting closer to trial, the court expects you to come in for a couple of conferences. One is called the Motion to Set Conference, and another one is called the Settlement Conference. At the Motion to Set Conference, you're expected to certify that you have done things to try to settle the case, but unfortunately haven't been successful yet. You have to produce certain information like financial statements and your position on the various issues. The other side has to file a response in basically the same format. The court looks this over and has a conference in which it tries to help the parties and their attorneys come to a settlement in the case. If not successful at that hearing, the court will generally set a trial date and some related deadlines. One of those related deadlines is another trip to court on the settlement conference. And again, the parties produce financials in a short statement to the court about the status of the case. And again, the court tries to assist the parties in reaching a settlement without a trial. Finally, if a trial is necessary, you will have been required to do certain things, like exchange exhibits and witness lists. All these are requirements of the court so that the case proceeds in hopefully a predicted, professional, and appropriate manner. One of our judges likes to say that going to trial is like playing poker with the cards face up. And he says, why do that if you can make a decision about settlement with all the expense and uncertainty of a trial? Best wishes to you. Once again, this is W Soenksen, Senior Counsel at Coates & Frye.